call it.
Yep. Okay, first case on the docket this morning, People versus Prentice, case number 235153. That is the set for a probation violation hearing. Mr. Herman, are you actually appointed to that?
I was, yes.
This was set for 9 a.m. It's now 9:03. Mr. Prentice is not here present.
You have an update to for Judge. Mr. Prentice left. I'm not 100% sure. Successfully completed, and we have verified that after we left rehab on December 20th. After we had no contact with the supervising agent, Charlotte County, or myself until 2 days ago. I had some text messages, conversation with him, telephone, and call supervising agent. Trying to get a hold of him. Didn't do that. But his court date today is this afternoon. Report at court. I tried to get a hold of him a couple times since your judge. I asked
Mr. Murphy, has he tried to contact?
No, Judge, I had no contact with just in fact, I wanted to get an updated contact from Mr. McFadden. That's the contact he gave me. I tried that. Those numbers happened.
Okay, based on the information provided by both probation and Mr. Gerber here this morning, I think benchmark appropriate. Mr. McDowell, I'd like to treat this as just an additional probation violation. Okay, as the court assigned that will proceed for premises practices case, which is present. Next matter is versus Courtroom, case number 245324.
I'm going to check and see this. All right, checked out in the hallway.
Had any contacts?
Not since the last phone date. The phone, I've got about 3 different phone numbers. The one phone number is disconnected. The one doesn't ring. And the third phone number is now wrong. Somebody answers it, but they tell me I have the wrong number. So I have an email, I've sent emails, and had a response back.
All right, I'm going to pass this matter for now before we, once we're done with your docket, we call the case. It's appeared by then, decide what to do, because I got the trial.
We do. And for the record, at the last status conference, I had indicated to Mr. Courtroom that the plea offer was what Mr. Courtroom would have made, which is what the offer is. We would enter a plea today, and that was our understanding leaving. So there was that offer made. My understanding that we were on the same page as taking care of that issue. And I know Mr. Courtroom is sick. I don't know. I would tell them, but I did a brief search in the UP to see if it was an obituary of Mr. Courtroom. He was very sick and asked to get something unusual happened. I didn't find anything either. And he lives in the UP, so I don't know if there's an issue transfer. He's always comfortable with some sort of.
Okay. All right. So we'll just pass that for now. Also at 9 o'clock, we got first clause. For record, that's file number 245352.
Mr. Ross is not outside. I've had good contact with Mr. Ross. We had a status conference, we adjourned last time because he had surgery. He did tell me there was what the documents, and I don't know if. So I asked for a show.
I'm sorry.
I'm checking to see if you have any failure to appear. It doesn't, we don't have any. So roughly new case, any prior issues. Doesn't have very much history. In terms of felonies, we did a lot of misdemeanors. More than half a dozen.
Just looking at the file, we did adjourn the December conference for this certain procedure. There was medical documentation provided of it. So I'm satisfied that he, did have a procedure scheduled for next December. So, and the court doesn't find any prior failures. So the court will set this for a show cause status conference at its next date.
I will.
You want to see Mr. Crawford's?
I will.
On the record in People versus Brian Crawford, case number 245558, registered to elect Mr. Crawford as present during the court today. I can have counsel with your appearances on.
I think I will.
Mr. Gerber, you had to do 1% today.
Judge, Mr. Parker is willing to accept the offer that was sent by the people. The offer is out on Larson for $1,000, $120,000, which is second. Counts 2, 3, and the original. I do have that produced.
Yes. Just helps that an accurate statement. Mr. Crawford, have you had an adequate opportunity to go through this plea agreement and talk to Mr. Gerber about that? Is that how you want to go forward today? Raise your right hand. Solemnly swear or affirm the testimony you're about to give, the truth, the whole truth, nothing but the truth, so help you God. Our officer likes to be able to see those things. All right, Mr. Crawford, you're going to be pleading guilty to one count of larceny as indicated by Mr. Gerber of $1,000 or more. As a second habitual offender, that means that the maximum possible penalty you can face would be up to 7 years. That would also fine or the value up to 3 times the value of the property. With that in mind, are you currently on any kind of probation? Then with that maximum possible penalty in mind, what is your belief in that terms? Right now, you have certain rights. I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you if you're at trial to question those witnesses. You have the right to have the court order any witnesses on your behalf if you're at trial. You have the right to remain silent during a trial, not have that signed against you, right? Testify at a trial yourself. On understand all those rights. Understand you're going to be giving up, waiving all of those rights by pleading. Also, you don't have an automatic right to appeal the plea that you're making here today. You wanted to try to appeal it or get it reversed, you have to ask the Court of Appeals to hear your case. If they can say no, then that would be the end of it. Does anyone threaten you with anything to get you to plead guilty? Has anyone promised you anything other than what you said here today in court? Is it your own free choice to enter this plea? Are you pleading guilty because you target? So the information I have indicates this happened back at the beginning of August of 2024. Is that correct? And on that date, read here in Crawford County. And what the information alleges is that it looks like you stole some things. Was this rental place?
It was not in a building, it was at a house, I was laid outside. In the yard.
All right, so this alleges that you stole some items from an individual, Alan Nichols, here in Crawford County. Did you do that? Oh, okay. Is that motor worth? Do you have any reason to believe that that motor less than $1,000? Take any other items?
I got there. Looking around, they went there, homeowner, put it in my side of the stuff. Go to that, that she- They said, yeah, come here, come get the stuff. Got there. One of my side, they waited about half hour. Nobody came, so I didn't feel like we left. And we meet them, come to the cabin. Pay them, they want to sell. Following weekend.
Let's follow, co-defendant pled guilty in district court, right?
Yes.
And your co-defendant admitted to the other additional items from that residence?
I don't know just what her plea was, or whatever, but she was guilty to what the other. We never took anything.
Mr. Crawford, your co-defendant pled guilty to taking some orders.
None of that.
No question. Co-defendant pled guilty to taking orders. Yes. You were in court that day, right?
Yeah, but I didn't hear exactly what you were talking about. That's what, if I was working, or I never went to paper.
You're aware that your co-defendant took the criminal as well?
Yeah. None of that. That's the problem.
I think we have the elements of larceny. If they took it, then they can never left the property.
Mr. Crawford, the co-defendant was your daughter.
Not my biological daughter. She lived with me when the family separated. She came to move with me a couple of years ago. My mom moved to Texas.
You're the acting parent. Her, she's approximately 19.
And she lived with me.
You guys went to this property, you took the canoe and the oars and moved them to another portion of the property off of the main area onto the trail.
I did not. I did not touch anything other than hold on.
Did she do that while you were there?
She dragged one canoe over to where there was already a pile.
I don't think we have to to the crime.
Yeah, I don't don't think so either. I mean, based on. I think what we'll do at this point is I'm gonna get this trial calendar. Mr. Review will set this for cut off. So as well. Testimony, I don't. Ms. Coe, how many days of trial? Well. Ms. Coe, in particular, time.
What prepared for?
So I'm gonna set it at 60 days. Probably get a date. I will set this for final status next month. So are you anticipating practice?
Not sure. Yeah. Probably learn some things that we can do with that, but I will. Look at those files.
Not at this time.
Right, so the court will send out notice of the date, time of the trial, as well as the status conference that'll be next month. Proper now, that's important to see that. Okay. Thank you, Mr. Roberts. Next matter is at 9:30. We'll take a short recess and come back.
I think,
This is, stats conference today.
Judge, the offer was tendered in this matter, Mr. Detective, CSC second come down. Mr. Wells and I actually discussing this matter, so I think we just got it up, find out. And I spoke to this court yesterday, that people are.
Coke, is that an accurate statement of the current?
I plan to revoke the offer in 30 days. Involves a minor child, very young child, 6 years old. I'm asking for the first available child.
How many days in trial?
I would say the trial itself is only going to take 1 day. These are probably the hardest if we get to report something for 2.
And I would agree with that.
I've got Ms. Coke's opinion on this already. How much time do you ready?
We're ready, so whatever sense of God.
All right, then I'll set this for next available trial date. I will set it for a plea cutoff in 30 days. So, Mr. Wells, between now and another hearing in February, between now and then, talk about any of the offers. Coke, are you interested in taking a trial?
I don't think so.
We'll send out notice of the trial dates as well as the final status conference and plea cutoff in 30 days. Ms. Coke, any other dates that I can address? Wells, do you have any questions? Okay, thank you. That's all. Yeah, Mr. Eisenhower.
I want to check, Judge. No, Judge, Mr. Eisenhower is not. Outside.
Okay, Ms. Anderson, I know that you're connected. Was there anything that, any information you had on this file? You see that you did file a motion regarding Mr. Eisenhower.
No, I have had zero contact with Mr. Eisenhower. I've tried to reach out on a couple numbers I had on a previous case with him, and with no luck.
Okay. All right, and he was ordered to appear today. The court signed an order back in December for him to appear to show cause why he has not applied for pretrial services. So he's not here for the status conference or for that purpose. So the court spoke the last paragraph one for his arrest. The court ordered that Mr. Eisenhower respond be revoked. Once he is arrested, the court will enter an order requiring him to be held in County Jail, and then the court will set it for a hearing status conference for the next date filed with his arrest. Anything further for the record? Mr. Chairman?
No, Judge.
No, thank you.
Ms. Anderson, thank you. You're free to disconnect if you'd like to.
Thank you.
Next hearing.
I would just take a couple of minutes to go as a pellet paperwork as well.
Okay, so we'll take a short recess. time sensitive. Okay. Versus Patel, Mr. Patel, around the podium, please. This is People versus Patel, case number 245300. The record should reflect Mr. Patel is present here in the courtroom today. This is the date and time set for sentencing the matter. Mr. Patel, you had a chance to go through your sentence report and talk to Mr. about that. Mr. Gerber, are there any additions?
No, you want
This code have any additions? Have any challenges? Have any victims that wish to address the court today?
Yeah, sure. Melissa?
Is that somebody who's appearing for?
I believe she is, yes,
Okay.
the victim's mother.
Ma'am, can you tell me your name, please?
Melissa Myers.
Okay, are you calling in on the matter in People versus Patel?
Yes.
Okay, and the prosecutors indicated that you're the mother of the victim in this case, is that correct?
Yes, Your Honor.
Okay, this would be an opportunity for you to address the court or anyone else that you'd like to address here today for purposes of sentencing. Mr. Patel is present here in the courtroom today, so please proceed whenever you're ready.
Thank you. Thank you for allowing me to speak today. The impact this has had on my daughter has been significant. She was 14 when he decided that he had the right to take her innocence from her. She was so happy and loving, and now she is angry. She does not sleep. She has been in counseling. She is a different kid, and the worst part is she blames herself. And it's not her fault. He took something from her. He took her innocence that she can never get back. And I would simply ask that the court make him pay for that and prevent him as long as they can from doing that to someone else. Thank you.
All right, thank you. Did you want to remain online here for the remainder of the hearing?
Please.
Okay. I'm just going to go ahead and mute you so that we don't have any background noise or anything, okay?
Thank you.
Ms. Pope, anything on that?
I think the victim's mother spoke appropriately as to what the sentence should be. The MDOC recommendation is 4 months. To you guys have.
Mr. Gerber, anything on that?
very briefly, judges, Mr. Patel has a brief, limited criminal history. But my questions, Patel has a duty to help you. I don't think I was a bad check, just that some.
Mr. Patel, is that a no? All right, I did review the report, familiar with the facts of this case. I also part of the review of the police department report prepared reviews of individuals involved. There's also a lot of information in that report about her history. I take all of that into account on what the attorneys have had to say, and Ms. Myers certainly with what you've had to say here today, and I do appreciate you appearing and giving your comments. It's always important for the court to understand the effect that crimes have had on victims as well. So I appreciate you making that statement here today. That certainly informs me about the total circumstances here as well. This is very concerning behavior, obviously. Someone engages in sexual contact with a person, particularly with someone who didn't want that contact. That indicates to me Mr. Fellows, you're only well, what you want. What's the thing you do with the time you're not involved, the fact that it's going to have on your life, damage that you might do. This whole situation in general is concerned with the actions of yourself. Victimizing this young person, really looking for guidance, support, advantage of somebody who wasn't really so, I do think that the plea agreement is appropriate, even though I think a higher sentence is certainly justified in this case. I understand the reasons for the plea agreement in this case, not requiring the victim to have to come forward and testify what happened. So I think that warrants some consideration. I do think the recommendation is appropriate. It's important to the plea agreement in this case. The court has been sentenced to 7 years and 15 years in addition to corrections. Credit for 55 days served. The court has been ordered that do not have any verbal or electronic physical contact with the victim. Record either directly through another person. He must not be within 500 feet of the resident school place of employment. The court has been ordered that a crime victim's assessment about $30 or cost of $325. Testing $60, $90 HIV testing. Are there any kind of monitoring sanctions involved in this charge? Just want to make sure I know it's not.
There will not be any lifetime electronic monitoring. When he does parole, he'll be on. It will be discovered. Okay, that's just.
You have the ability to seek an appeal of the sentence. Already now.
But it's not, Judge, I reviewed it and I gave him a copy as a copy.
Failure. All right, people versus Courtroom, and that is file number 24524. That's contact.
I haven't had any contact. I received 3 phone numbers of the same numbers I have. Check the clerk's office with the 5 phone numbers on record. There's one additional number which I already had. That's the number that I indicated before the long one. So I haven't had any contact in the last hour.
Let's go.
Bench warrant, jury trial for jury.
All right, I think in light of the statements that both counsel made on the record here today, with your contact with Mr. Courtroom, I think the bench warrant would be appropriate at this time, so the court will request the president to prepare that. The court will sign that bench warrant in order that Mr. Courtroom's bond be revoked. Court will adjourn jury trial set for Monday. During jury trial set for Monday. Once Mr. Courtroom is arrested, the court will order that he held jail without bond. The court will set the status conference as soon as they file his arrest.
It was clear as check.
People versus Rachel Nish, case number 45350.
Yeah, people.
Thank you, Your Honor. Jason Thompson.
Next up, for sentencing this matter, Mr. Thompson, I know that you have a challenge to the guidelines, so we'll address that in just a second. But Ms. Nish, if you had an opportunity to present reported comments, Thompson about that. And Mr. Thompson, aside from that challenge, are there any actual corrections? In terms of the challenge to the guidelines, the challenges to OB-19, I did receive your written objection. I did have to
Your Honor,
and I did get that. But I forgot to mention.
yeah, so that's what we're.
And I don't disagree with the defense counsel that we need to be sort of weak in terms of scoring. We really don't know what happened during that time. The court has all the information we have. So I don't have any additional. Thank you.
Yeah, so I think the most compelling thing is the videotape. I did the web. And most it shows three of them in the center. So I understand. There is an did something to justice. So action. Just for the record, Mr. Thompson, I just want to confirm briefly in case that change, excuse me, the change result will be 0. So will be 0. Total of 0 will be 1.
Yes, that's how I score it.
So any objection to that?
No.
Mr. Thompson, you can have it.
No other challenges.
Ms. Cole, have any additions, deletions, or corrections?
No.
Have any challenges? Anything like that?
Yeah, I really don't know what the court can do with this niche at this time. Known her in the professional capacity pretty much since I became prosecutor. The court is very familiar with her. She's 31 years old. She had 2 boys that have been removed from her care. Saw a letter from her boyfriend that she wants to move to Texas and pay her kids here when she gets out. She doesn't want to go to prison because she's going to do drugs in prison. I don't know what other excuses there are. Ms. Nish has had a chance to do Bear River outpatient. She did once an inpatient. She's basically just continued to commit crimes her entire life. I don't know what other answers there are for her. I wish like many of the people that come before the court lots of times that she was able to stay on the straight and narrow, but she continued to test positive for drugs and then continued to possess the drugs. So I asked the court to sentence her for
Yes, Your Honor. Rachel's so sad. Anyone else? She's not there. Struggle with she's struggling
has requested the court consider a local sentence. She advises me that she's very scared of going back to prison because currently we're in a very easy relapse in prison for drugs available. It's not her last stay. That's what she goes there. She doesn't have the experience around the jail. She does. You know, she has not good for jail. So she prefers to stay in her local jail. She would put it for serious including. So for those reasons, she has to consider.
Ms. Nation.
Sorry, I didn't.
So I did review the report. I'm familiar with this issue before. So your background, circumstances are ready. Sorry, disagree with what both lawyers have to say. It's really unfortunate. Some tragedy of addictions. Well, allowed. It's a cycle that you have to inquiry as of yet. Still young, still have time to do that. So, or the elder day. It's just more time behind bars and worse, you know, problems to your health and eventually. That's where it ends. Ultimately. Doesn't have to be that way. So time to do that. Relapse and back to recovery all the time. So hope that you don't give up on it. However, I will say that in terms of what to do at this point, or give you a shorter sentence and then get out. All those drugs are still available, just like they are less available on the street. These would be corrections sanction. That's programs that are available. Got a choice not to take drugs, whether that's in prison or street. Yeah, make a choice to get them out. That's it. Got that. So I say all of that. So the court is going to essentially follow the recommendational guidelines have changed. So guidelines and so on. Prior history, status of the court is going to send you to the Department of Corrections for a period of 10 years because of your parole status and jail credit. The court is also required to make that sentence consecutive. Crime victims assessment of $130 or cost of $25 during fees of $300 state costs. You have the ability to seek an appeal of the sentence. Yes, you're acknowledged those.
So Richard, now we receive dates to show this.
Your Honor, Ms. Nish has acknowledged the form of against.
Versus Clear, case number 245360. Reflect Mr. Clear's present report today. And counsel.
Here's what we have people.
I think you'll have to.
So you're ready, kind of.
This is our first status conference. The playoff was extended in this matter. It's a 4-year felony. Mr. Clear is indicating that he is considering that offer. So I would simply passed up, you got this one, Senate for the big off, and that's 30 days. I anticipate residents of it.
Okay.
So, yeah. we'll withdraw it the next one.
We cut off Thursdays. Now and then, stay in touch with us for our date. Back for decisions. Except that year. Okay.
Yeah.
Still getting hearing that.
I am, but that's the special prosecutor. So
Oh, okay.
I am ready.
He's representing himself. We're prepared to go. We do have a victim via Zoom.
There's also there's like a. Probably want to afford. All right, on the iPhone, sir, can you tell me your name, please?
Pete Kosifis.
Mr. Josephus, okay, we're getting ready to start the hearing on People versus Michael Lovely. Is that the case that you're joining us on?
Yes, sir.
Okay, so we've got some matters that we need to address first, but then when it's time for the victim's impact statement, then I'll let you know, and then you'll have an opportunity to address the court and anyone else that you'd like to, okay?
Okay. Thank you.
All right, Mr. Lovely, I know we've gone through this. I need to do this at the beginning of every hearing now to make sure that number one, you understand that you have the right to have an attorney. And previously, I've gone through with you the representing yourself, correct?
Yes.
You understand all those risks. Like that. Stuff today. All right. Mr. Lovely, did you have a chance to read through the pre-sentence report? Also, the report on your probation violation. Read that too. Is there information in there that needs to be corrected or changed? Ms. Cope, do you have any additions, deletions, or corrections?
The restitution amount was changed from what's in the PSI. We submitted that restitution request to the court. The total was $286, Mr. Pete Kosifis, and $1,002.51 to Vintage Wine Company, Attention Newark, PTID.
It's 786. 286, Mr. Josephus.
Yep.
1251.
$1,002.51.
Any other corrections?
No.
Great job this morning. Okay. Corrections to the violation report. Mr. Josephus, now would be the opportunity for you.
He actually wanted to speak.
Ms. Coe, I'm gonna go forward with your allocution. So,
I have known Mr. Lovely in a professional capacity for over a decade. He's always just sort of skating the line, making poor life choices from being poor, using drugs. I do think, from what I've talked to my probation officer, that he's actually clean. Then his eviction, he has a new baby. His significant other, who has a warrant out for her arrest, is not clean. I don't think, but he has full custody of that baby, or is taking care of anything he's out of the relationship. So he's making some good choices, which is good to see, because otherwise we're just really to see. He's young-ish, 38. He's probably too old to be committing felonies. He's one felony, 12 prior misdemeanors. The recommendation is 120 days. 1 day credit, I think is appropriate. I know he's working now, and he has some things to say with court, but I really just don't know what to do with Mr. Lovely. He doesn't stop doing dumb stuff. He can keep going to jail and not have any money because he's going to keep going to court costs. It's going to be a cycle for the rest of his life. And I'm thinking that maybe it's 40 or a better time for him because I'm going to stick a scene.
all right, Mr. Josephus, now would be the opportunity if you wanted to make a statement today.
I'm good. I've just wanted to watch, that very disappointed that it affects my reputation here, and that's about all I have to say. That I wish they wouldn't have done it. So, okay.
All right, thank you.
Yep.
Mr. Lovely.
I'd like to apologize. Sorry to do it again. And my kids, stop for things in that way. Stop when I did. That's my biggest downfall is it's not working and struggle with that aspect. Got my decision. So I run a lawyer and I represent myself. I know what I did. I'm trying to beat around the bush and get out of it any which way and nothing. I just did what I did. I'm very sorry. And then I'm back to work and I'm up to Vanderbilt. So I think I have custody of my daughter. I'm in my mom, grandmother, can help me out with keeping an eye on her and everything. Just hope that it's not too much time because I don't want to. Tired to be away from her. She's lost a lot already. I got a decision. Just tired to get through anything.
Right. Well, I did read through the report, what happened in the circumstance, certainly bad judgment, Harvard. Yeah. Yeah, it's hard. You're in a bad financial position, but something versus anything. There's really no way you're not going to get caught. There's cameras everywhere these days. It's just not something that I don't think really. And it is the type of crime that results in damage and loss to it's not the victim's crime. And so some punishment is appropriate in this case. I think probation is also appropriate. That's what provide oversight. And most importantly, for payment of restitution. We are taking responsibility for this. That's a good thing. Part of that is for the cause is probation. So the court finds a sense within the guidelines address the issues of punishment, consequence, probation, address. So the court is going to send you on count two, file 541 probation. Or it's going to send you probation. Or it's going to adapt this decision to that probation, all the terms and conditions listed in the report. That includes, that restitution, which is $286. Proper county clerk dispersed. See this. $1,002.51.
I do not.
Court has been ordered to serve 120 days of Crawford County Jail. You have credit for 1 day served. Private assessment of $130. $30 while you're on probation. $25 court costs. As to the probation violation in this case, the court is essentially consents you to the same amount, give you any extra time than that. This is to account for what happened. So the court is going to violation sent you days. You have credit for 27 days on probation violation file. And of course, below probation. Costs. You have the ability to appeal all of these sentences tonight, showing Mr. I'm going to give you some papers, Mr. Lovely. These are going to explain to you how to request appeal of the sentence, how to ask the lawyer. Whether you probably go to the officer at this time. And as soon as we get this well brought up.
As they say goodbye to a man whose life was lived to the fullest, with a faith demonstrated in countless good works, with a mission richly fulfilled, and a soul rewarded with everlasting life. As for myself, Jimmy, I'm looking forward to our reunion. We have much to catch up on. Thank you, Mr. President. Welcome home, old friend.
Moving tribute to Kevin Carter from his former political rival
On the record in People versus Brandy Welch, case number 235271. The record should reflect Mr. Welch is present here in the courtroom today. If I could have counsel for your appearances on.
Christy McGregor, I have special prosecutor on behalf of the people.
Thank you, Your Honor. Jason Thompson, attorney for Brandy Welch.
This is set for a status conference today. We have a trial set to proceed next Monday. Thompson, how does your side want to proceed today?
Yeah, we've had plea discussions. The prosecutor has made a plea offer for Ms. Welch to plead guilty to count 1, possession of methamphetamine, as a second habitual offender, not a second controlled substance offender, but a second habitual offender. That's been reduced to an amended information, I believe, as well. Let's take that, please.
McGregor, is that a correct statement of the offer?
That is correct, Your Honor. And I do have an amended information if she's going to take.
So it's visual time.
Yes.
Yes, habitual second as opposed to controlled substance second.
Thank you.
Well, have you had an adequate opportunity to speak to Mr. Thompson about this? Is
Yes,
that how you wanted to proceed today?
yes,
You raise your right hand, please solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
yes.
Ms. Welch, are you still on probation?
I was on probation prior.
Okay, that was a different issue. All right.
I have not appeared on any probation violation
Yeah.
case, so as far as I know, the answer is no, but the court is aware I'm recently back on this case.
Okay. All right, you understand that by pleading guilty to possession of methamphetamine as a second habitual offender, the maximum penalty you face would be up to 15 years. So you say yes or no?
Yes.
With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear in trial to question those witnesses. You have the right to have the court order any witnesses on your behalf to appear at trial. You have the right to remain silent during a trial, to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights?
Yes,
Understand that you're giving up and waiving all of those rights, including the right to have a trial.
correct.
Also, you don't have an automatic right to appeal the plea that you're making today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of the appeal. You understand that?
Yes,
Has anyone threatened you with anything to get you to plead guilty?
no,
Has anyone promised you anything other than what we said here in court today?
no,
Is it your own free choice to enter this plea?
yes,
Are you pleading guilty because you are guilty?
yes,
This happened back on August 31st of 2023, is that correct?
correct.
Do you recall that day?
Yes,
And on that day, you were here in Crawford County.
yes,
And while you were here in Crawford County on that day, did you have possession of some methamphetamine?
yes,
Did you know that that's what that substance was?
yes,
Did you have any legal right to have any amount of it at that time?
no.
Gregor, are the people satisfied with the factual basis?
Yes, Your Honor.
Yes.
Gregor, are the people aware of any threats, promises, or inducements other than what's placed on them?
No, Your Honor.
No, Your Honor.
Mr. Gregor, are the people satisfied that the court complied with statute and court will undertake this?
Yes, Your Honor.
Yes, Your Honor.
As well as the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that you are guilty of this charge. The court will accept the guilty plea. We'll set this matter for a sentencing hearing. Will be notified of the date and time of that hearing. Anytime, Mr. Crowder, you can.
Yes, Judge.
Mr. Crowder will be with you for a pre-sentence.
Okay.
Gregor, anything further today?
No, Your Honor.
That is further, thank you.
And like the plea, the court, just for the record, will return to your trial cell for January.
Thank you, Your Honor.
We'll have sentencing probably about a month. You'll have to meet with probably Mr. Melvin. Do a PSI.
Series set for 11:45, we'll be in recess.
have both files pulled, but the 5233 is the one that you went to prison, so. Thank you.
Okay, Ms. Marcuse, are you able to hear me okay?
I am. Good morning, Judge.
All right, good morning. We'll go on the record. This is People versus Terry Lee Johnson, case number 235233. If I could have both counsel put your appearances on.
Sierra Coke on behalf of the people.
Catherine Marcus from the State Appellate Defender Office on behalf of Terry Johnson.
Okay, and Ms. Marcus, there's, I do not have Mr. Johnson connected. I don't know if he was written or how you want to proceed with regard to his presence.
I believe there was a video writ for Mr. Johnson, at least initially, but the date was changed. I would waive his presence if he's not ready. If there's no MDOC writ for today.
Okay.
Not showing.
Okay, the file does not reflect that a writ was prepared and he is not connected, but you indicated that you'd like to proceed regardless.
Yes, Your Honor. If the court does grant a resentencing, he would obviously be present for that.
Sure, okay. All right, I did have a chance to review your brief, Ms. Marcus, and the attachment to it as well. I also had a chance to just review the file generally, including the transcripts from the sentencing hearing. Ms. Marcus, anything further that you wanted to present today by way of oral argument in support of your motion?
Yes, Your Honor. I would like to first just respond to a couple things in the prosecutor's brief. First, Mr. Johnson can challenge the sentencing guidelines for the first time in a timely filed motion to correct invalid sentence. And under the court rule 6.429, this court has authority. If it concludes that there was an error in scoring the guidelines, it has the authority to grant resentencing. The prosecutor in paragraph 6 of their response to the motion says that the standard for scoring the guidelines is whether any evidence is an any evidence standard. That case law is outdated by about 17 years. The standard is preponderance of evidence, and that there's a 2008 Michigan Supreme Court case, Ozentowski, determined that the sentencing variables are to be scored using the standard of preponderance of the evidence, and the any evidence test is no longer good law. So moving to the substance of the motion, Your Honor, OV18 was scored here at 20 points. There were two tests in this case. There was the breath test done shortly after the time of the stop and arrest. And then over 2 hours later, about 2 hours and 7 minutes later, the blood test. The breath test was 0.164, the blood test 0.214. And for the scoring of OV18, it matters whether the correct number is above or below 0.2. In this case, the appropriate score would have been 15 points, because from what we know about how alcohol is absorbed by the body, the blood test over 2 hours later is likely not accurate. And the breath test is that much closer in time is a better representation of what Mr. Johnson's blood alcohol content was at the actual time that he was driving, which is what the variable assesses. None of this information, none of the facts here are new. Both tests are summarized in the pre-sentence investigation report. The only thing that's new for the court is the affidavit of the expert explaining in a summarized fashion why Mr. Johnson's blood alcohol content was likely not close to 0.214 at the time of the actual stop. And if the court has questions about the science there, we would ask for an evidentiary hearing where the court could hear from that expert.
Okay, thank you. Ms. Koch?
Your Honor, I did a response. I filed it. I don't disagree with defense counsel's statement about the required burden. I did speak to the expert about this case. Frankly, when I see these cases, even if they're taken very close in time, blood is always higher. There's a reason that the PBT is not allowed to be used. It's not an accurate test. We can't use it in trial for that reason. He refused the test, which is why they had to get the blood test. Blood tests, even if it was the intoxilizer and the blood test, the expert explained to me that the blood tests are usually higher. It really has a lot to do with, when they stopped drinking and when they stopped eating, which is what the expert's going to say. I don't think we can get anything closer other than what we have in this case. The delay, frankly, was due to defendant's refusal and why we got there. It is the only accurate test we have, and I do not think there was a problem with sentencing for all the reasons I outlined in my brief, and I'd ask the court to deny the request to correct the invalid sentence as it was based on the evidence and the lab tests used. Thank you.
Thank you. Ms. Marcus, anything you wanted to say in response?
That, Your Honor, that test becomes less accurate as time goes on, and there are states, New York is one of them, where after 2 hours, blood test is presumed inaccurate. I think that Dr. Simpson could speak more to the science there, but that would be my response to the prosecutor's point.
Okay. All right, thank you. Again, I did have a chance to review the briefs. I did look at the expert's report and opinion that was submitted by the defense. And, first of all, I would say this is a sentencing hearing, so the rules of evidence don't strictly apply. The court doesn't have to apply the rules of evidence. I can take testimonial statements like the affidavit from the expert in this case and give it evidentiary value without the testimony. And I don't think there's anything wrong with the science that was applied. I think, the expert's opinion makes sense in light of just what we know about how the body metabolizes alcohol. And so I don't think that further testimony would shed light on it, because I don't think there's really a lot that could necessarily be disputed about his opinion. It is what it is. I think it comes more down to the standard that the court has to apply here. OB 18, I think Ms. Marcus accurately cited OB 18 and what it requires. And so then the court looks at, kind of goes back to where the presumption is created, which is 257.625A6. Which statutorily allows the court to presume that a person's blood alcohol content at the time of the test is the same as it was when they were driving. And I think it's accurate that that is a rebuttable presumption. And so the court has to look at, has there been enough evidence put forward as part of this motion to rebut the presumption that Mr. Johnson's blood alcohol content was above 0.20 at the time he was driving. There's a couple of things I would note. Number one, I think the legislative intent behind that presumption is in part based on the argument the prosecutor's making, which is that individuals should not be able to benefit from delaying an accurate test of their blood alcohol level, which they can do by refusing to take a PBT in the first place, by refusing to consent to a blood draw, the need to get a search warrant, the delay in transporting someone to the hospital. In many cases where individuals are uncooperative with police or hospital staff, which can further delay the actual taking of the blood sample. And so the presumption's in place to prevent individuals from benefiting, creating those kind of delays in order to have a lower blood alcohol content. Obviously, that cuts both ways. In this case, it resulted in Mr. Johnson actually having a higher blood alcohol content. But I think the principle applies, which is Mr. Johnson should not be allowed to benefit by receiving lower sentencing guidelines because of delay in being able to get his blood alcohol sample. The court finds that the blood alcohol amount at the time that he was tested with the blood test is the most accurate reading of what his blood alcohol content was. I would also note that in order for his blood alcohol content to go up, by the time that he was stopped by police officers, he must have consumed enough alcohol for his blood to actually reach that level. He wasn't able to consume any alcohol following the traffic stop, obviously. So he had already consumed enough alcohol to result in that kind of level. And so regardless of the expert's extrapolation of what his blood alcohol might have been at the time, the court finds that it's not sufficient to overcome the presumption that the level that it was when his blood was tested is an accurate reading of his blood, of the level of alcohol in his system at the time of the arrest that he was, at the time he was driving. And that, coupled with, again, what the court finds to be the legislative purpose behind the presumption, which is that individuals should be able to benefit from the delay, the court finds that it would defeat the intent of the statute to find that Mr. Johnson should be entitled to lower guidelines simply based on the fact that he engaged in voluntary actions to delay the testing. So for all those reasons, the court finds that OB 18 was properly scored, and the court will deny the challenge to OB 18 and the request for resentencing. So the Ms. Marcos, if you would prepare an order that just reflects based on the reasons stated on the record, the motion is denied.
I will do that.
Ms. Marcos, anything further that we need to address for the record today?
No, Your Honor, that's all for today. Thank you.
Let's go.
No, thank you, Your Honor.
All right, thank you. That's all for today. All parties are free to disconnect. That also concludes the court's morning docket. The court will be in recess until 1:30.